Mr. Speaker.
Let us pray. As Canadians and as Albertans, we give thanks for the precious gifts of freedom and peace which we enjoy. As members of this Legislative Assembly, we rededicate ourselves to the valued traditions of parliamentary democracy as a means of serving both our province and our country. Amen. All honourable members are aware that the House commenced sitting today 1/2 hour later than the usual appointed time. This was because of the delayed flight which transported His Excellency the Governor-General of Canada to Edmonton, making possible his visit to this esteemed legislature. Several procedural difficulties were considered. Hours of sitting are prescribed in standing orders and can only normally be altered by the motion of the House. Whether adjournment occurs automatically by way of standing orders or by motion of the House, the Chair has the power in exceptional circumstances to vary or suspend for a period of time the normal hours of business of the House without question being put. Authority for this is found in Erskine May, pages 246 and 47, under the title Informal Suspension of the Sitting. The Speaker may order a suspension of the normal hour of convening or suspend the House once it has already started sitting, even if it supersedes standing orders, on those rare occasions which remind us all that rules must remain flexible and accommodating. Speakers at Westminster have invoked informal suspensions of the sudden collapse of certain members, on the failure of the lighting system, to investigate bomb scares in the palace, and to attend certain royal functions, among other reasons. The visit of His Excellency would, it seems, rank with the last example, and it seemed appropriate for the Chair to, in consultation with the various House leaders, suspend the sitting for 1/2 hour to allow all honourable members the opportunity of meeting with Her Majesty's representative for Canada. The Chair will therefore put no question to the House on this matter and trusts all members concur in the judgment of the Speaker under these circumstances. Clerk.
Introduction of visitors.
The Chair would acknowledge the presence in the galleries of certain former members of the House, and perhaps others will join us during the course of the afternoon. But I do hope that all members will join me in giving a welcome to those members, former members who are in the galleries, and those who have come back to visit with us on this occasion.
Presenting petitions. Reading and receiving petitions. Presenting reports by standing and special committees. Notices of motions.
The opposition?
Mr. Speaker, after a question period under Standing Order 40, I'll be seeking unanimous consent for the following motion to the Assembly. Be it resolved that the Legislative Assembly of Alberta express to Premier Bourassa and to the people of the province of Quebec our belief that the failure of the Meech Lake Constitutional Accord in no way represents a rejection of the province of Quebec, its people, or their culture, and further expresses our unshakable commitment to a strong and united Canada.
Introduction of bills. Tabling returns and reports. Introduction of special guests. Ministerial statements. Oral question period.
Leader of the Opposition.
Yes, Mr. Speaker, to the Deputy Premier. Mr. Speaker, Canadians now have had a couple of days to reflect on the death of the Meech Lake Constitutional Court. Mr. Speaker, and I'm sure the Deputy Premier spent a great deal of time thinking about, since he was one of a handful of Canadians who was actually directly involved in the negotiation process surrounding the court. Now, Mr. Speaker, I'm sure the Deputy Premier must be terribly disappointed, but even he must admit that the process was totally flawed and totally unacceptable to Canadians. Mr. Speaker, and the fact that our Prime Minister makes no apology for orchestrating the whole affair and gambling with the future of Canada, I think, frankly, is disgusting. The Prime Minister is no longer a solution to this problem, but very much part of the problem, Mr. Speaker. But I want to say optimistically, I believe that down the way at some point, I think cooler heads have to prevail right now, Mr. Speaker, but there will be constitutional talks again. And my question is to the Deputy Premier is this: has the Alberta government now made it clear, absolutely clear to the federal government, that this province will never again be part of a flawed process that leaves out the people of Alberta and the people of Canada in that process?
Well, I share the Honourable Leader of the Opposition's concern for the failure of certain provinces to ratify the Meech Lake Accord and therefore its failure. I do think, however, that he is perhaps taking an overly simplistic approach to the reasons for its failure, and I would caution against being over simplistic. One has to recognize the fact that the process which was followed was indeed the process which was established in the 1982 Constitution of Canada, and that in examining that process, the First Ministers in their most recent meeting, which the Honourable Leader of the Opposition attended in Ottawa, made it part of the recommendations of the subsequent accord that there would be a thorough review of the process itself. Our government was strongly committed to that particular accord, the companion accord, and believes that indeed we must re-examine the process by which constitution changes will take place in Canada in the future. I do want to add, however, that the one key element as it affects Alberta's ambitions with respect to Senate reform had been included in the companion accord, and that, of course, was swept away with all of the other benefits which would have flowed to this province from the constitutional change, and that was the creation of a commission which would have, in fact, had that full public participation built into that process with respect to Senate reform. And that, indeed, amongst all the other matters which have been lost to this province, was a great loss indeed, and would have, I believe, gone a long way to correcting the impressions and, indeed, the process itself with respect to future constitutional change.
Mr. Speaker, I don't deny that there weren't some good things in that second part of it, Mr. Speaker, but I say to the Deputy Premier that the fact that in '87, behind closed doors, the Constitution was decided and then said there can be no changes, not one dotted I or crossed T, it's so perfect, led to the problems that we faced. And I say that the last closed-door pressure session that shut out every Canadian but the First Ministers, there was a visceral reaction against that from the people of Canada and the people of Alberta. And I say to you, it's not overly simplistic to blame that on that process, Mr. Speaker, and that's one man that brought it about, and the First Minister shouldn't have participated, Mr. Speaker. But my question then to following along from the Minister's answers, Mr. Speaker, has the government then finally learned this government finally learned that refusing to hold public hearings in 1987 was wrong and set the stage for the failure of this accord? This government could have had public hearings as they did in other provinces. Do they now admit that this was wrong?
Mr. Speaker, Alberta and the actions taken in Alberta did not lead to the collapse of the Accord. The honourable member knows full well that the resolution was introduced into this Assembly in June of 1987, allowed to stand over until the fall sitting. Several months ensued where there was broad consultation in Alberta as to the impact of the Meech Lake Constitutional Accord. His party decided, which was their right, to form a committee to go across the province and to seek out opinions. Our caucus decided they would take a different approach. And in my own case, I held a number of meetings across this province in order to discuss the implications of the Meech Lake Accord. But I think the honourable leader will agree with me that attendance at those meetings, and including his own, was not that substantial. It was only as events developed subsequent to the passage in this Assembly in other provinces that public interest began to increase. And I think that was wrong. It should have been there all along. But I certainly do not want to leave the impression that this government was in any way responsible, as implied in the leader's question, for the collapse of the Meech Lake Accord. That is not so, and should not be part of the impressions left with the people of Alberta or Canada. And indeed, the honourable leader of the opposition has already brought forward a notice of motion to reaffirm that the people of Alberta did not bring about that collapse. And I would think that it may be a nice political shot to take at this stage of the game 3 years later, but the facts do not bear out that in Alberta in any way contributed to the collapse of the Meech Lake Accord and the subsequent isolation of Quebec.
Oh, Mr. Speaker, there was a frustration with this process right from the start. And if the minister knows, from our public hearings, we came back and said that there should be public hearings. We brought in a lot of other amendments. They were all voted down by this government. Now, Mr. Speaker, I say that the minister really does underestimate that process and what the visceral reaction was in the rest of Canada. And I say to him that that was really the major problem in dealing with this whole area, Mr. Speaker. And if he's ignoring that, we're doing it at our own peril. But I'll give him a question, Mr. Speaker, to look at the future. Not much you can do about the past, Mr. Speaker. But will the Deputy Premier take this chance in the Assembly to assure Albertans that the government has learned from this experience and offer his personal guarantee that any future constitutional discussions, if there are any, will be open to all Albertans through public hearings?
Mr. Speaker, the honourable leader of the opposition is quite in error to again try and place the blame for the collapse of the Meech Lake Accord on this province, or the procedures that were followed within Alberta. I quite agree with the honourable leader of the opposition that the public was in fact disturbed by the process. That was absolutely evident throughout the whole. The honourable member for Jasper Place is yapping away again. He's not prepared to listen to anything in this Assembly unless it's words that emanate from his own mouth. Mr. Speaker, the fact is, however, that we are absolutely committed, first of all, to a process by which we once again resume constitutional discussions to end the isolation of Quebec and its 25% of the Canadian people. Secondly, that we are committed to the Companion Accord. And that Companion Accord had a number of items in it, including the issue of determining a new process by which constitutional change will take place in Canada. And that will include a process for public hearings. Now, whether or not that should be determined by and have them uniformly determined across the country, or whether each Parliament is going to establish its own process, is surely a matter which must be discussed at greater length. But that is a commitment that our government signed on to. And furthermore, and finally, let me say this. When our Premier signed that accord, that Companion Accord, and put his signature to it, It was his firm commitment and intention to honor that, and that will always be Alberta's intention when we sign our name to anything.
Second main question, Leader of the Opposition.
Mr. Speaker, second question also to the Deputy Premier. It also has to do about process and democracy, Mr. Speaker. But the government has shown its true colors in refusing to allow full debate on the game ranching bill and subject that legislation to closure, Mr. Speaker. It's no secret, at least it shouldn't be, that this bill is controversial, and literally thousands of Albertans have let the government know in no uncertain terms that they are opposed to game ranching. So the government uses the ultimate procedural club to avoid having to debate this unpopular and misguided bill. Now, Mr. Speaker, this undemocratic tactic seems to be their new way of doing business on controversial issues. First it was the sale of AGT, and now it's game ranching. And I say again, if we learned anything from Meech Lake, process is important. And again, we're following undemocratic process here in this legislature, Mr. Speaker. That turns people off. Now, Mr. Speaker, on May the 2nd, during the Stettler by-election, the Premiers reported saying this, and I quote, "Game ranching is not allowed in Alberta, and we are not considering allow it." Now, I'm sure the voters in Stettler took the Premier at his word. My question to the Deputy Premier, how can the government do such a complete about-face on such a controversial issue?
Mr. Speaker, I answered that question in the House the last time it was raised with respect to the fact that the New Democratic Party in this Assembly, the official opposition, made it absolutely clear at the outset that they had no intention of doing anything but frustrating and delaying the passage of the legislation. And when they make their signal so abundantly clear, it is absolutely certain, Mr. Speaker, that it is a waste of the time of this Assembly to just listen to such edifying discussions as how to raise elephants in Africa.
Mr. Speaker, maybe if the Deputy Premier was paying some attention, he would see that there is a relevance to that and know what's going on. And my question, I could say to this Deputy Premier, here's a major bill, a turnaround from that minister and from the Premier less than a year later, and he's saying 4 hours is too much debate in the legislature. How can he justify a position like that? 4 hours is too much to debate an important bill.
Mr. Speaker, there will be more hours than I care to imagine spent on the bill before it reaches final passage.
Mr. Speaker, then I ask the Deputy Premier, that's how long we spent in second reading before he jumped on this undemocratic process. And again, this shows a government that's afraid of debate or just wants to get out. I don't know what the reason is, but I want to ask the Deputy Premier this, because there's all sorts of groups around the province that are extremely concerned about this bill, because we haven't had much time in this legislature, second reading only 4 hours, and I say because of the government's about-face and because of the widespread dissatisfaction with this bill, would this government do the honorable thing and leave this bill on the order paper at least till the fall session, till they have other groups talking about it?
Well, I would remind the Honourable Leader of the Opposition that second reading has not been concluded as yet. And when the bill is called again, there will be some additional time in second reading before a closure is invoked. There will be time in committee, and there will be time in third reading. So for the Honourable Leader of the Opposition to try and leave the impression that only 4 hours is going to be spent on the bill is quite I have to search my mind for a word to describe his allegation, but it's just not in accordance with the facts. That's the best way I can put it. It is not in accordance with the facts. And furthermore, Mr. Speaker,
Sorry. Honorable. Thank you. Glengarry. Edmonton Glengarry.
Mr. Speaker, I don't think there's any doubt that Albertans were disgusted, as were all Canadians, with the process that we went through in the recent constitutional discussions. Albertans want to be part of the development of a constitution. They want to be part of understanding what it is that should go into Aboriginal rights, what should be a definition of effective in a Tripoli Senate, and so on. I'm somewhat shocked and surprised by the answer given by the Deputy Premier, Mr. Speaker, with respect to mandatory review. As I understood the Deputy Premier, he said that the government would consider whether or not this would be done at a national level or whether there would be individual reviews by the provinces. My first question then is this to the Deputy Premier. What possible reasons could the Deputy Premier give Albertans for not having a separate and a distinct process for Albertans to have public examination, public review on any matter affecting the Constitution?
The leader of the Liberal Party was not listening. The leader of the Liberal Party should listen again. The honorable leader of the Liberal Party should know that what I said was that the companion accord, which was signed in Ottawa, and he was there, he saw it and heard it, said that there would be a new process developed for constitutional change, and that would likely and most likely include a process of public hearings. And let me repeat that, a process of public hearings. And what I said today was that it has not yet been determined whether that should be exactly the same in each of the provinces or whether each province should design its own process for public hearings. It would seem to me quite logical for the people of Alberta to tell us, as elected members of this Assembly, what type of public hearings they would like to have. And so we're going to listen to them, rather than tell them what type of public hearings there will be. That's the way the leader of the Liberal Party may want to do it and say, this is the way it's going to be in Alberta, but we are going to listen to what they would like to say and how they would like to say it, and then we will, in this Assembly, determine how public hearings and public involvement in the development of the Constitution will be held. And I would remind the leader of the Liberal Party that this province led the process of public participation with respect to developing a Senate reform model. And how was that done? A select committee of this Assembly was established, and it went across this province and across this country, and over a period of almost 3 years determined what Albertans wanted for a Senate reform model. And that was, in my view, a model which should be followed elsewhere in Canada. But that doesn't mean that it should be imposed on other provinces if that's not the system they want to establish. And for the leader of the Liberal Party to get up in this Assembly and suggest we are not interested in that process is quite wrong.
Mr. Speaker, I'm delighted that the Deputy Premier is finally admitting the faults of some of the actions of the government. I'm delighted to hear that the Deputy Premier is going to call on Albertans to see how it is that they would like to set up these public hearings, because the Deputy Premier and his government have denied Albertans that right. My question is simple, Mr. Speaker, Mr. Deputy Premier. When can we expect from the government some initiatives on a new process for Albertans to be involved in a new constitutional thought process? And most particularly, when can we get from the Deputy Premier commitments as to when this public process that he's talking about will start?
Mr. Speaker, the leader of the party he follows at the federal level just said, don't do anything for a decade on reforming the Constitution. Isn't that amazing? And now he comes into this Assembly and says, today, we should have a new process established. How ludicrous can the leader of the Liberal Party be? Who does he support? Or does he support his former leader, Trudeau, who said, let's not do it for 20 years? Come on, Mr. Speaker. Let's have a little honesty in this Assembly from the leader of the Liberal Party.
You won't be around.
Well, Mr. Speaker, we can't get anything out of the Deputy Premier. He won't tell Albertans when it is this process will start. He won't tell Albertans that there will be a public process. He's going to leave it to somebody in Ottawa to determine it, just like you have for the last 3 years. My last question is to the Attorney General, the Minister responsible for Indian matters, Indian affairs in our province. Aboriginals have not been happy in our province with the role that our government has played with Aboriginals. They've not been happy. They've not been happy with respect to the constitutional matters that should go into our Constitution. I'd like to know, Mr. Speaker, from the Attorney General, what initiatives he intends to put forward to clearly establish the position of Aboriginals from Alberta insofar as that new Constitution is concerned.
Mr. Speaker, the leader of the Liberal Party knows full well that I'm the minister responsible for constitutional issues in our government. And I want to just I know the honorable leader of the Liberal Party may want to ask whoever he wishes, but the fact of the matter is what he has just said is absolutely wrong. The Aboriginal people of Alberta were given, those Aboriginal people for which our government has specific and direct responsibility, the Métis people, have a clear understanding of what we propose to do, and we carried out our commitment fully to the Métis people after the '87 discussions collapsed. Now, with respect to involvement of the Aboriginal peoples, that was part of the subsequent accord which was reached in Ottawa. And the honorable leader of the Liberal Party knows that, and yet he comes into this assembly and says that it was not part of the deal. The fact of the matter is that under the Constitution of Canada, Section 91, the federal government has responsibilities for Indian, and the courts have determined Inuit peoples. But they have left it clearly to the province to determine how Métis people should be dealt with. And before this assembly today are the most progressive forms of self-government legislation ever devised anywhere in Canada for the Métis peoples of this province, and I make no apology whatsoever for that matter. The honorable leader of the Liberal Party says, what about the Treaty Indians? The fact of the matter is he should know his Constitution and know that they are the constitutional responsibility of the federal government and not the province. But where there have been requirements, we have met them, and we will...
Thank you. Now, the chair has allowed today almost 25 minutes to be taken up with the first three questions. That's because of the seriousness of the issue. But the chair also wants to point out that in future the supplementaries must be much more succinct. And in addition, once you've asked your question, it doesn't become a shouting match back and across the floor. You get a chance for your other supplementaries, and that's simply got to stop. Chair recognizes Drumheller, followed by West Yellowhead.
Thank you, Mr. Speaker. Because Trudeau and his gang have succeeded in derailing a process that was working to achieve true Senate reform, can the Deputy Premier say what the implications are for such reform now that Newfoundland has rejected that process?
Well, Mr. Speaker, the options are not very good, obviously. The Prime Minister has said that there will not be First Ministers' conferences on the Constitution while Quebec is not participating, and I understand that. Quebec has said they will not come to constitutional conferences until in the future because of the rejection of Quebec by certain provinces and not passing Meech Lake. And it's going to be very difficult then to get Senate reform back on the constitutional table. And I found it very, very puzzling indeed as to how somebody, including the leader of the Liberal Party, could have said, kill Meech Lake, that will help Senate reform. And for the life of me, I don't know how Senate reform is going to get back on the constitutional table when the table isn't there. And his leader of his federal party says it will be a decade before we're back at the constitutional table. I hope it will be sooner than then, but I don't know the answer at this stage.
Supplemental, Mr. Speaker. One of the mechanisms within the Meech Lake Agreement established by the First Ministers in 1988 and 1989 was Alberta's task force on Senate reform. It is evident that this mechanism did some very valuable work when one considers the companion accord that was arrived at in Ottawa 2 or 3 weeks ago. Does the Deputy Premier see any role for this task force in the future?
Mr. Speaker, unfortunately, as members know, the mandate that Alberta received from the premiers unanimously in Saskatoon in 1988 was to conduct the task force hearings, and then that was renewed last year in Quebec City. But because of the fact that Quebec has now said that they have been excluded from the constitutional process and will not attend the Premier's Conference in Winnipeg later this year if it's held, that that mandate is not likely to be renewed, and that is very regrettable because, in fact, the work that task force accomplished was considerable and led to all those additional steps which would have been taken had Meech Lake been passed and the subsequent accord been put into action, including the creation of the National Commission. It's a tragedy for Senate reform that Meech Lake has been killed.
West Yellowhead. West.
Mr. Speaker, I understand that the government has been getting some correspondence from municipalities across the province who aren't at all thrilled with Bill 26. That's the Treasurer's legislation to allow them to take approximately $95 million out of the pockets of Albertans by canceling the income tax rebates.
Shame.
I'd like to remind the Minister of Municipal Affairs of the position of some of these municipalities. The Council of Onaway is strongly opposed to Bill 26, and of course the letter goes on. We as a council are definitely against this type of selective tax and request the government reconsider their decision to eliminate the income tax rebate. That, Mr. Speaker, is from the town of Hinton, signed by His Worship Mayor Ross Griswold. And there are more I'd like to table with the legislature. Will the Minister of Municipal Affairs admit that this bill is unfair to customers who live in areas served by private utility companies and withdraw this bill to protect the municipalities?
Questions out of order because the matter is in committee of the whole stage. Chair No, I'm sorry, it's more than process. It is not. Calgary Buffalo.
Thank you, Mr. Speaker. This is to the Solicitor General. To the Solicitor General, Mr. Speaker. Proposed changes to the Liquor Control Act will... Solicitor General? Proposed changes to the Liquor Control Act will give the Cabinet power to regulate entertainment in bars. Now, it seems to me, just as in the case of Meech Lake, that it's totally inappropriate for changes to be made by the gang sitting around in the back rooms without full input and debate by members of this legislature and the public, and that includes the businesses, on specific proposals, not just ruminations of the minister, but specific proposals. Now, last Thursday, in response to my suggestions and concerns, the minister indicated that he would consider asking the new advisory council being established under his legislation to conduct hearings on the issue. I'm wondering whether the Solicitor General will now agree to have that advisory council being set up, hold such public hearings with respect to the proposed entertainment regulations before they are passed.
Thank you, Honourable Minister. This question's out of order as well. The bill is gone past third reading stage, as a matter of fact. Member for Wainwright. Member for Wainwright.
Thank you, Mr.
Thank you.
Thank you, Mr. Speaker. My question is to the Minister of Economic Development. Rural development has been vital to the survival of our small towns and villages in Alberta, and Wainwright has been no exception. It is felt by many rural Albertans that many of our economic development programs have been geared for big business. What is the government doing to encourage our small business in rural economic development?
Mr. Speaker, I'm happy to report to the honourable member that the Premier has recently established under the Ministry of Municipal Affairs an extensive study whereby we are looking at how we can better improve our support for rural Alberta, recognizing that there is some rural depopulation taking place. But notwithstanding that fact, we do have an extensive network of regional offices that does offer a wide variety of specific support programs to both municipalities and to individual small businesses within the rural population of our province. In addition to that, we do work specifically with a number of local economic development authority boards, of which I meet with on a regular basis, And we do have a fairly extensive series of programs for the small business community.
Thank you. Could the minister explain to us how the management assistance program contributes directly to our small business in our rural area, and who is eligible for that?
Mr. Speaker, we work in conjunction the majority of times with chambers of commerce in bringing forward the management assistance programs. To date, there have been some 6,000 businesses that have worked with their local authorities and our own department in making sure that they do have proper business plans and whatnot. I should share with the honourable member too that it was just recently we brought forward our business initiatives for small communities, whereby we do have an actual injection of cash so that they can develop their own economic plans to greater benefit and contribute to the development of their community. In addition to that, as I've indicated on previous occasions in the House, we do have our capital loan program, our interest shielding program, and a number of other programs that relate directly to the small business community.
Member for Edmonton Belmont.
Thank you, Mr. Speaker. My question's in order. It's not on the order paper, nor is it hypothetical. It's about a judgment that was... Oh, indeed. Thank you, Mr. Speaker. It's for the Minister of Labour. The Alberta Court of Appeal recently ruled that the sale of a business creates a break in employment contracts for non-unionized employees. In simple terms, Mr. Speaker, this means that long-standing employees could be treated as freshly hired workers by their new employer. It means, Mr. Speaker, that non-union employees could suffer cuts in pay, cuts in severance pay, cuts in vacation pay, and have arbitrary changes to working conditions and salaries, among other things. Given the serious ramifications of this decision, will the minister commit to immediately introduce appropriate amendments to the Employment Standards Code to protect these non-unionized workers?
Mr. Speaker, the member opposite has raised an issue that is causing some concern to me as Minister of Labour, because there's no question that that is not the intent behind the legislation. The act that the case actually considers is the old Employee Relations Act and not the new code, although it specifically mentions in the judgment that the provision in the Employment Standards Code, which is new, is substantially similar. Still, the intent had been to protect the employees in cases of mergers and amalgamations and sales, and we are now looking at the options that we can pursue to bring the practice to match the intent that we had.
Mr. Speaker, the decision means that employees with 20 or 30 years' experience may have their salaries slashed or be dismissed on 1 week's notice. They need to be protected now, Mr. Speaker, not wait for the next legislative session or until the minister gets some kind of opinion. So I would ask, how long does the minister intend to take, or how long does the minister intend to make these employees wait before she's prepared to protect their rights?
Mr. Speaker, just as long as it takes to get it right. Next.
Followed by Edmonton Whitemud.
Thank you, Mr. Speaker. To the Minister of Technology, Research and Telecommunications. This government is aware, Mr. Speaker, that Unitel has launched a massive publicity campaign in support of its application to the CRTC for the right to horn in on the profitable long-distance Canadian telephone system. This is particularly ironic when you consider that Ted Rogers, one of the Unitel's major shareholders, is trying to block similar competition in the cable TV industry where he has a monopoly. To the minister, given that industry analysts have described Unitel's CRTC application as incomplete at best and inept at worst, will this government intervene at the CRTC hearings to oppose Unitel's application, or at least insist on some safeguards for AGT customers?
Mr. Speaker, indeed, we are monitoring the application by Unitel very, very closely, and there is some likelihood that we will intervene in order to ensure that the interests of Albertans are looked after. Unitel, obviously, by virtue of the change in jurisdiction to the federal government and by the policy of competition, is entitled to, of course, make that application. They will do so on a basis that CRTC will ultimately have the opportunity to examine thoroughly the application in all of its contexts, and we will be following it very closely, and in all likelihood, as I mentioned, we will be there in order to monitor the situation.
Thank you. I hope it isn't just likely you'll be there. You'd better be there on behalf of Albertans. Mr. Speaker, the Sherman report, which was done on behalf of Canada's telephone systems, including AGT, shows that long-distance competition in countries where it has been allowed drives up local rates, reduces level of service, while at the same time failing to deliver on the promised productivity gains. Now, given that this government has lost its regulatory control over AGT to the CRTC, will this minister agree today to table any written agreements he has that leads him to believe that this federal body will be looking after Albertans' interests, particularly as to local rates?
Mr. Speaker, the Sherman report to which the honourable member refers provides, and I believe the honourable member should in fact know this, it provides a basis of application by CNCP that was not near the type of terms that are currently coming forward from Unitel. As a result, the Sherman report based its findings on material and facts that are really not relevant at this point in time from the standpoint of Unitel's. But Mr. Speaker, I'm pleased that indeed we have received assurances from the federal government relative to the CRTC. Firstly, taking into account all of the tariffs, all of the programs, all of the services to rural Alberta, and embodying those as part of the CRTC regulatory regime. As well, we will be participating, along with other provinces, in the future development of telecommunications policy. We will be participating in a group of experts to analyze the mechanisms of the CRTC regulatory process in order to improve that. And indeed, CRTC will have a presence right here in Alberta.
Member for Edmonton-Whiteman.
Mr. Speaker, it would appear, according to reported statements, that the minister responsible for lotteries has acknowledged that some government employees participated in this June the 16th fundraising golf tournament. I question Mr.
Member, this is a matter of privilege. If we could just hold on for half a moment, folks. Just a moment. The chair is just giving caution to the member because the waters are already clouded. With the question period on Friday, the chair has received not only one notice of privilege with regard to this matter, but now two. So I'll listen very carefully to what the question is, and it may well be ruled out of order. Thank you very much. Edmonton-Whiteman.
Mr. Speaker, would you like me to start over? Say he did or didn't.
Keep on going.
Mr. Speaker, to the minister responsible for lotteries, assuming those reports are correct, would the minister inform this House exactly how such government employees participated directly or indirectly in the golf tournament under question?
Honourable member, the question is out of order. Because, as previously explained to the House, Edmonton Meadowlark, if you'd like to clean your ears out, thank you. Let's go to Calgary Bowl, followed by Edmonton Centre.
Thank you, Mr. Speaker. Mr. Speaker, my question is for the Minister of Culture and Multiculturalism. Mr. Minister, in view of the continuing controversy over the native artifacts recently purchased by the Provincial Museum, would you please tell this Assembly when you will deal with the natives to address their concerns?
Mr. Speaker, the Department of Culture and Multiculturalism and the Provincial Museum have been dealing with the many native bands for decades, addressing the concerns that they have with respect to preserving their religion and their culture, and we're going to continue to do that. On the specific issue of the Scriber Blackfoot collection that's the subject of some controversy, Mr. Speaker, we invited members, representatives, and other interested parties from the Montana Blackfeet to the museum last week to discuss this. It's unfortunate that one or two of those individuals breached a trust that we were attempting to establish, Mr. Speaker, by attempting to remove from the museum without authority one of the bundles. However, we are going to continue our efforts to meet with those individuals. Next week, museum officials, on Wednesday, as a matter of fact, will meet with officials of the Blood Band to continue a dialogue on their concerns. And we'll be meeting with the Pagans in early fall again to continue to address the concerns Native have with respect to their material culture and preserving their religion and these artifacts.
Thank you, Mr. Speaker. Mr. Minister, as these artifacts are from Montana, would you please explain why an Alberta museum would be interested and involved in the purchase?
Speaker, there seems to be some misunderstanding about the origin, the ownership, previously of the artifacts and the current ownership. While, Mr. Speaker, the artifacts in question were in fact in Montana most recently, they did not all originate in Montana. In actual fact, the Blackfeet originated in some respects very close to where Edmonton is now and as far north as Lesser Slave Lake. The material moved back and forth, but I can safely say that a good portion of that material originated with Blackfeet people in Alberta. The reason the museum is involved now, and our Alberta Museum is involved specifically, is in an effort to fulfill our mandate to preserve the material history and culture of this part of the world. There was a danger that the material involved being sold by a private individual in Montana might have gone offshore and be lost forever. We were able to acquire it through the cooperation of the federal government. In terms of returning the specific bundles to any individual or any specific band, Mr. Speaker, there is some dispute, some considerable dispute, as to the actual ownership of those bundles. Many of the people who put them together are deceased, and that is the purpose for the ongoing discussions, and it is our considered opinion and certainly our dedicated effort to work with the Blackfeet people to revitalize their traditional religions and culture. That's always been our concern, and it will continue to be so.
Edmonton Center.
Thank you, Mr. Speaker. Mr. Speaker, over 6,000 Albertans every year suffer from various forms of brain injury. Brain injury from motor vehicle accidents, some from sporting events, from bicycle, and even on the playground among children, Mr. Speaker. And yet at a recent meeting, representatives of over more than 30 agencies and family groups supporting persons with brain injury raised the many unmet needs of these Albertans and concluded that out-of-hospital care is marked by inadequacy and confusion, that these people are basically just falling between the cracks. Mr. Speaker, it's hard to know who to ask this question of, in fact, because they can't apply to the Social Service Minister for AISH, they can't apply to the Healthcare Minister for Home Care, they don't know who to go to. I don't quite know who to go to, but I would like to ask the Minister of Health if she would undertake to raise this matter with the Premier to determine who these 6,000 Albertans who are brain injured with their families can go to for support in this province.
Speaker, the Honourable Associate Member for Family Services and myself have already raised the issue and at the present time have an interdepartmental committee working on the issue for us.
Thank you.
Point of order.
After question period. Point of order, I don't know what I said. Thank you, Mr. Speaker. This must be now the 8th interdepartmental committee that the minister has, and yet, as I said, Mr. Speaker, these 6,000 Albertans and their families are suffering each and every day from a lack of concern in terms of who they can go to for in-home support, for attendance to help them day to day. So I'd like to ask the Minister of Health or whoever over there can tell these Albertans who they can go to for support today in terms of proper discharge planning from hospitals with follow-up with trained staff in place for these Albertans who so desperately need this kind of care, Mr. Speaker.
Well, Mr. Speaker, we have launched, as the Honourable Member is well aware, some important treatment reviews, not only from the point of view of the patient, but also from the point of view of training Alberta health professionals with respect to how we might better deal with the growing reality of the brain injured in our health systems. That includes the role of the Alberta Hospital Panoka and the role of health units across the province and the whole supportive role of home care. I don't have a quick, simple answer, which the Honourable Member for Edmonton Centre seems to seek with respect to a lot of health questions. I can tell him that we are looking very carefully at the issue. Certainly the question of home care for those under 65 is very much a part of this question as well, although that certainly doesn't just apply to the brain injured. But I would hope that we might be able to come up with a more comprehensive plan for treatment and support services in the community with respect to view that's already underway.
Thank you. Edmonton Centre said both. All right. Calgary McKnight. Still recognized.
Thank you, Mr. Speaker. Mr. Speaker, the federal government recently announced a commitment of $300 million to work cooperatively with provincial departments of education in an attempt to stem the high dropout rate at the junior high and senior high school levels across Canada. To the Minister of Education, given that Alberta's dropout rate is an alarming 30%, does the Minister have concrete plans for assessing these monies in order to address this serious problem without delay?
Yes, Mr. Speaker.
Mr. Speaker, is the Minister prepared to announce the terms of the federal-provincial agreement and to circulate the information to all stakeholders so that consultation can take place?
No such agreement exists, Mr. Speaker.
Thank you. Thank you, honourable members. We have a couple of points of order. We have 3 matters of privilege. We have a standing order 40. We will start with Calgary Buffalo.
Thank you, Mr. Speaker. The Speaker, you ruled out of order a question which I asked, and I'm standing under Standing Order 13, subsection 2, to the effect that Mr. Speaker shall explain the reason for his decision upon the request of a member. I must say that I don't understand the basis for the ruling. In fact, in four years, I've never encountered a ruling I find harder to understand. The question I asked, Mr. Speaker, was with respect to regulations that are proposed to be passed under the Alberta Liquor Control Act that has been now passed this legislature, and with respect to the process of enacting such regulations. I specifically referred in my preamble to statements that the minister made last Thursday night with respect to a matter that he said he would take under advisement at that time, and I was asking him further to that particular matter. This is a question that is very similar to many questions that have been asked multi-times in this House with respect to whether or not the ALPAC project will be licensed without having further hearings. My question was whether or not the minister is going to have public hearings before he enacts regulations. It's not a question with respect to specific legislation that's before this House in any way. Now, if it were with respect to the legislation per se, then an issue might arise with respect to anticipation, but since the legislation's already passed and not coming before this House, it couldn't be anticipation. So the only principle that could possibly be applicable is that you can't ask about the Alberta Liquor Control Board regulatory process. And if you can't ask about it now, you can't ever ask about it, and that's got to be a surprise to every legislature in the world. So I must say that I am saddened about this, Mr. Speaker, because we all work hard to represent the interests of our constituents and not our own interests, and this is a matter of public interest, and I've been deprived, I fear, wrongly of a question. And we don't get that many in this House, Mr. Speaker.
Hear, hear. Well, thank you, honourable member. I'm sure that you have the same kind of concern as the member for West Yellowhead had. Honourable member, this is not a back and forth dialogue. Order. There's a great difficulty when the House gets to this stage of the sitting because of the progress of various bills, and the chair has made it quite evident on a number of occasions, including at least once earlier this spring, if not twice, as to what the process is, and the chair's hands are tied by that process. The chair would also like to point out that the chair is a bit concerned that the honourable member wishes to take things on a more personal level. The member that sent a note here, I think, is one of the rudest notes that the chair has received in the 4 years. The chair would also, there are a number of other items that could be dealt with, but perforce the chair really just needs to draw the attention of all honourable members to the statement to the House. On June the 15th of 1989, again April the 19th of 1988, and again June the 30th with regard to 1988, and it's the whole matter of anticipation was ruled out of order there, and the sum and substance of it is that once the bill's gone past the second reading stage, then the honourable members have tied their own hands with respect to question period. Thank you. That's it. Now let's listen to Edmonton Whitemud, please.
Mr. Speaker, I stand on under Beauchene 410, section 410.14. And Mr. Speaker, I have 2 points to make in this particular regard. The question and the preamble I had given clearly indicated that it did not relate specifically to the statement that was filed to me. A copy of it was filed to me from the minister responsible for lotteries, or filed by his lawyer, did not state or make any reference to the question of employees involved in that golf tournament. The breach of privilege was related to other matters that the minister responsible for lotteries made certain claims, or his solicitor made certain claims. So, Mr. Speaker, to begin with, I need some explanation from your point of view as to how this ties in to that particular breach of privilege. And then secondly, again referring to the same subsection, when it makes specific reference to orders of this day or orders of the day, my understanding is that the statements that have been filed claiming breach of privilege, the two that I'm aware of, are not on the order paper of this day, that they in fact will not be dealt with at this time. So I would like, if you would, Mr. Speaker, to explain to me as to how you see this relating to the breach of privilege, and how you see it relating to orders of this day, bearing in mind 410 subsection 14.
Well, honourable member, with due respect, to repeat again, in case the amplification system wasn't good enough before, the original matter was raised by yourself on Friday. There was a response by the Honourable Minister of Public Works, Supply and Services in his capacity as Minister for Lotteries. There was then the supplementary was asked by yourself, and again there was a response, a somewhat spirited response by the Minister of Public Works, Supply and Services. Within question period itself, notice was given that privilege would be raised. Again today, the letter was received in my office around about noon with regard to the matter of privilege. As a matter of fact, it was in my office. It's not there. Anyway, notice was there that privilege matter was to be dealt with. The chair also had conversation with the House Leader for the Liberal Party to say that the matter indeed would not be dealt with today, but that the letter had been received. Notice was given to the chair that another letter of privilege was likely to be forthcoming. That letter from yourself, Honourable Sir, was delivered in my office at 12:35. Therefore, both yourself and the Minister of Public Works, Supply and Services knows that the matter is to be dealt with in terms of privilege. That makes it sub judice, because until the arguments can be heard on either side with respect to the matter of privilege, the matter really is sub judice. We have a rule, therefore, is not to be the subject of question period. Now, Honourable Member, you yourself commenced your question today. The chair intervened reluctantly, but gave admonition. And again, the member was allowed to continue, but it was nothing more than leading us down the direction of dealing with the whole matter that is to be dealt with tomorrow, because of the Governor General's delayed visit today with regard to this whole matter of privilege. That's the reason why you were then had your privilege, to use the play on words of asking the question, removed from you today. The matter will be dealt with tomorrow. Thank you. Now, are we going now to another point of privilege, or is it order, or is this standing order 40? Thank you. I'm sure the member for West Yellowhead can look after himself. Thank you.
Mr. Speaker, I'd like to ask under Standing Order 40 the reason why I was ruled out of order.
13-1.
13-1.
Well, again, honorable members, the chair could also quote back some things there about not being able to get into question period. It really is not the subject of a point of order. And that's been dealt with in the House before as well. The chair has gone further to give explanations, and the same explanation given to the member for Calgary Buffalo applies to the member for West Yellowhead. Thank you. Now, let's hear the point of order. Edmonton Glengarry.
Order 11, sub 1. Speaker shall not take part in any debate before the Assembly. Mr. Speaker, it makes it very difficult for members on this side of the House to offer apology or to consider apology if they are unable to pursue a matter and find out definitively whether or not there are grounds to offer such an apology. Mr. Speaker, last Friday, from my review of Hansard, it was the Speaker that interjected during the debate and ruled, or at least admonished, the honourable member from Whitemud, Edmonton Whitemud, indicating that the Speaker was concerned about his comments. The Speaker made no comment about the fact that liar was used repeatedly by another honourable member, clearly out of order. But it seems that we can't, at least as members of the opposition, get to the truth of a matter. The lottery business is not a matter that we can pursue. It's not a matter that we can review in estimates of this Assembly. There is no other avenue open to us except to put questions to the honourable ministers and have them answered, and then, if we think it's necessary to offer apology, offer such apology. You give us no alternative, sir.
With due respect, honourable member, perhaps you would read all of the transcript of what transpired on Friday. Because at that stage, the chair was well aware of the fact that the Honourable Minister of Public Works Supply and Services had indeed issued the phrase liar, that this whole matter would be dealt with, and I said so if you bother to look to page 2136, that the matter would be dealt with when the matter of privilege was dealt with in the House, because the Minister had already said that privilege would be raised. And it is still the point when honourable members get themselves off onto tangents or hyperbole or whatever else and start getting into the area of making some charges to each other in the House, it is the duty of the chair to intervene. Now, honourable member from Edmonton Glengarry, you are a little bit off the track here, because indeed the point of place to do the exploration as to whether or not an apology would take place would indeed occur when we get to the matter of privilege. It's not to be a matter of question period asking further information. And the chair has pointed out both privately and publicly that tomorrow will be the day that the issue is dealt with. And I'm sorry, I'm much aggrieved that you feel aggrieved that the chair has been not carrying out its proper function. Standing Order 40, member for Vegreville on behalf of the Leader of the Opposition.
Thank you, Mr. Speaker. I'm pleased to rise and request unanimous consent of the Assembly to deal with the following motion under the provisions of Standing Order 40. Qu'il soit résolu que l'Assemblée législative de l'Alberta exprime au Premier ministre Bourassa et au peuple québécois sa conviction que l'échec de l'accord constitutionnel de Lac-Meech ne constitue en aucun temps un rejet de la province de Québec, son peuple, ou sa culture, et réitère son solide engagement envers un Canada fort et uni. Be resolved that the Legislative Assembly of Alberta express to Premier Bourassa and to the people of the province of Quebec our belief that the failure of the Meech Lake Constitutional Court in no way represents a rejection of the province of Quebec, its people, or their culture, and further express our unshakable commitment to a strong and united Canada. I think the motion speaks for itself, Mr. Speaker.
Monsieur le député pour la circonscription de Vegreville, it has proposed a request under Standing Order 40. Those members wishing to give unanimous consent, please indicate by saying aye. Aye. Opposed, please say no. Motion carries. Member for Vegreville.
Thank you, Mr. Speaker. There may come a time when thorough analysis of the process and content of the Meech Lake Accord needs to be done by people across the country, but I think we can all agree that the time now is to make it clear to people wherever they live in Canada that we remain together as a country. Our futures are much brighter if we renew our commitment to one another and to this country. It's our hope in the New Democrat official opposition, and I believe the hope of all members of the Assembly and people in the province of Alberta, that the people in the province of Quebec not interpret the failure of a particular process as a rejection of them or their culture. And we think it's important that that message be sent to them as soon as possible. And if the motion passes the Assembly, we ask that that be sent under your hand to them.
Thank you. Additional call, Edmund and Glengarry.
Speaker, I believe that it needs to be set out on the record that this whole matter of rejection is made or created by one individual. It was one individual from 1985 on that talked about Quebec being rejected if the Meech Lake Accord was not passed. It was one leader of our country who kept talking and re-talking and continuing to talk about that point. When you talk about something long enough, then people start to believe it. And I think it's important also to note that Albertans didn't like the Meech Lake Agreement, don't like the Meech Lake Agreement, don't like the process that we went through with respect to that Meech Lake Agreement and subsequent constitutional discussions. But under no circumstances can Albertans be interpreted as, because they didn't like the Meech Lake Accord, no way can it be interpreted that they were somehow against Mr. Bourassa or against the Quebec people, against brothers and sisters of our country. These are difficult times, and such times aren't made easier when expectations are built up in the minds of some Canadians and the hopes and aspirations and expectations of other Canadians are put down or suppressed or held back. Many mistakes were made in this constitutional process from 1985, 1987, just a few weeks ago and on. We've learned much from those mistakes. And I think that all of us can be positive now, can move forward towards the development of new strengths, new alliances from those lessons that we've learned. I don't want my country to fall apart or to split apart. I want every cultural group, and most particularly those Canadians who live in Quebec, to be part of my country and I part of their country. So we completely and entirely and wholeheartedly endorse this resolution. Thank you, Mr. Speaker.
Thank you. Deputy Premier.
I want to thank the official opposition for the sincerity of the views expressed by the Honourable Member for Vegreville and the Honourable Leader of the Opposition in bringing forward this resolution today, because I believe it is a genuine, indeed a thoughtful reflection of the views of this Legislative Assembly, as expressed unanimously in this Assembly in the fall of 1987, when the resolution in support of Meech Lake was passed. And I want to say, though, Mr. Speaker, that I find it hard not to respond to the remarks just made by the leader of the Liberal Party, as I would like to do, but in view of the particular importance of sending a positive message, not just to the people of Quebec, the people of all of Canada, that I urge honourable members to vote in support of this resolution brought before the Assembly today. But I must say this. The honourable leader of the Liberal Party has said it's the view of one man. And he didn't name that one man. I can only assume that he refers to the Prime Minister of Canada when he says that. But I can assure the honourable leader of the Liberal Party, if he thinks that that is the only person in Canada who feels that Quebec has been rejected by the failure of the Meech Lake Accord, then he is sadly wrong. And he was not listening to the thoughtful and, I thought, responsible views expressed by the Premier of the province of Quebec over the weekend to the people of Canada. And I believe that there are, unfortunately, many people in Quebec, perhaps the great majority of them, who feel that indeed English Canada has rejected them as part of this confederation. And so I welcome what I said earlier, the thoughtful, considered perspective put forward by the official opposition in the remarks made today, and I, on behalf of the government, share in expressing those views to our brothers and sisters in Quebec, our fellow Canadians. I thank the honourable member for Vegreville as well for introducing the remarks in French in this assembly. I regret that I am not quite capable enough of doing so myself, although I can say in all honesty I understood every word the honourable member for Vegreville said in French, and I say that in a kindly way. And I do then urge honourable members of the Assembly to provide the unanimous consent to this motion.
Call for the question with respect to the resolution. Those in favor, please say aye. Aye. Opposed, please say no. Motion carries. Let the record show unanimously. The Chair would also like to point out for the record that a question of privilege letter was received in the Speaker's office at 11:48 a.m. from the Minister of Public Works, Supply and Services. The member for Edmonton Whitemud had delivered to my office at 12:35 a notice of privilege, and the member for Calgary Buffalo at 12:35 also had delivered to my office another matter with respect to privilege. These items will be dealt with, will be at least voiced tomorrow after question period. Orders of the day. Government House.
Mr. Speaker, I move that you